Hi, everyone. This is attorney Lillian with Lily Legal. And at my firm, we do immigration law. I help my clients get status for themselves and their family using the U.S. immigration system. And I get to help clients all over the U.S. and all over the world. So if you have any questions about this or anything else immigration related, you can book a time with me over Zoom or in person by going to lilylegal.com or by calling my office at 508-443-1788. And as always, my contact information will be in the details, in the description for this video. Okay, so today I want to talk to you about how to remove the condition on your green card if you are no longer in a relationship with your spouse. That's what we're going to be talking about today. I am very excited. I am ready to get into this because I had someone come into my office that really needed this help. And from talking to them, I realized that a lot of people out there do not know what they actually are able to do, what is the best thing for them. So, it is really important that if you are in this situation, if you are married to a US citizen or permanent resident and you have a conditional residency, that you know there are options out there for you. And we are going to be going through what those options are and how you can basically benefit from it. Okay, so let's start with how do you even get a conditional residency? Why don't you have a permanent residency? So typically, when you file for a green card through your spouse and it's approved before your marriage is 2 years old, you will get a conditional residency, not a permanent residency. So what does that actually mean? So a conditional residency means that you will get a 2 year, quote unquote, 2 year green card. And you would then need to file to remove the condition before that 2 years is up. Generally, you will be filing to remove the condition with your spouse, right? You two will be filing jointly, asking the US government to remove the condition and give you a 10-year green card so that you can continue living in the US with your green card. Now, what happens when two people that are married separate or there's issues in the marriage and the other person is not the US citizen or permanent resident spouse is not willing to file that application jointly, is that the person that's not a US citizen or the person that has the conditional residency is now left out, trying to find ways to maintain their status, right? So again, typically you're filing jointly with your spouse to remove the condition. If this is not possible, then we're going to talk about the other options. All the options that I'm going to go over have one requirement, right? They all have different requirements, but they all include one specific requirement. Your marriage has to be real, right? We know this. Every marriage based case, you know, your marriage has to be real. But you have to show that since the time you got your green card, that you and your spouse have lived together, that you have had financial commingling of your funds, you have had all those things that you presented when you filed the first time. So you are still required to continue showing that you have that financial relationship, that you have that good faith marriage. That's all they're really looking at this stage, right? When you file to remove the condition, all the officer cares about is, can you prove that your marriage was entered into in good faith? That's it. Okay. So that's the basis of removal of condition. Now, what are your options when your spouse is not willing to file for you? So if your spouse Now, if your marriage is entered in good faith, but, right? So that's the starting point. Your marriage was entered into in good faith, but, right? And the first one is, but there was a divorce, right? It ended through divorce or annulment. Again, there's an asterisk for the annulment because if you annul the marriage, does the marriage actually exist? So there's a whole thing there as well. But again, if the marriage was real, right? You had a good faith marriage, but you got divorced, you are able to still file to remove the condition on your green card. And I'll go into like what type of documents you need to show for the good faith marriage, but that's really what they're looking at there. And I will even tell you a story about a potential client that had a bunch of issues, but we were able to get her case still approved. So just stay tuned for that. So one, good faith marriage, but divorce. The second one is good faith marriage, but you were abused, right? You were battered or you suffered extreme cruelty by your spouse. Okay. And then the third one is that terminating your status, right? You enter the marriage in good faith, but if the US government decides to end your residency, you will suffer extreme hardship. Okay. So remember, divorce, extreme cruelty, abuse, and then extreme hardship. So if you entered into the marriage in good faith and you got divorced, you can still remove the condition. If you entered the marriage in good faith, you're not divorced, but you suffered abuse during the marriage, you can still get the condition removed. If you entered the marriage in good faith, but you're not divorced, there was no abuse during the marriage, but you will suffer extreme hardship if you were removed from the US. If you were not allowed to remain a permanent resident of the US, you will suffer extreme hardship. So in these situations, again, you will still be able to remove the condition. That's really, those are the three core waivers that you have when you are not able to file with your spouse. Again, it's a given if your spouse passes away, but your marriage was entered into in good faith, and you can show that, you can also remove the condition. So those are the main ways that you can remove the condition if your spouse is not filing with you. Okay. So I had a client come into my office and she was distraught because there was so much going on in her case. There were restraining orders against her, right? Not against the US citizen spouse, but against her by the US citizen spouse. She was in the process of filing for divorce, but the divorce wasn't final yet. She did suffer some abuse during the marriage, but she really doesn't have documentation. It was a lot going on, and we had to figure out what's her best option, right? What can we actually do to get her to the point where she can get that 10-year permanent residency? And part of that process was going ahead and filing, even though the divorce wasn't final. She didn't have a lot of documentation of the abuse, but we had to figure out what her best option was. I knew that the divorce will be final within 6 months of the filing. So it made sense to go ahead and file for a divorce and then have USCIS access for that final divorce decree. So it really just depends on each individual's situation. But what I'm going to go through with you is, how do you prove good faith marriage when there's so much against you, right? You have a restraining order against you. You no longer live with the person. You are now living on your own. You don't even have contact with the person. The person, because of the restraining order, you weren't able to even get a lot of the documentation to prove your relationship, well, options are there for you. Okay. So I want to welcome everyone that is joining us. Hi, Tommy, all the way from Monrovia. Welcome, welcome. And then Bayan, thank you for joining us, and good afternoon to you too. Um, Again, if you have any questions for me, please feel free to leave them in the comments so that I can answer them for you live. If you are watching this on a replay, feel free to ask me your questions. I do go back and respond to you. If you're watching this on YouTube, again, feel free to put your questions there. I do go back and respond to you in the comments. And sometimes I even make a whole video responding to your question. So feel free to do that. Let's see. Someone has a question. So Benjamin has a question. Hello, besides, I'm guessing, I-130 immigration form to file for a child, is there any other form one have to file? So again, it really depends on where the child is and what you're filing. So typically, if the child is not in the US, you're just filing the I-130 with supporting documents, which will be on the instructions. If the child is in the US and they are an immediate relative of a US citizen, then you can also file the green card application, which is the I-485, with all the other forms that go along with that and the supporting documents. So yes, you would always need the I-130, but depending on where the child is, you might need other forms. If the child is outside of the US, first step, I-130, and then once it gets to once the I-130 is approved, you would then go through filling out the DS-260 and uploading all the supporting documents and the affidavit of support, the I-864. You will do all of that at the once it gets to the National Visa Center. But again, just depends on where the child is. Feel free to, if you want to talk to me about it, feel free to schedule a time for us to do that. Okay. So I hope that answers your question, Benjamin. So let's go to, how do you, right? You don't have a lot of documentation. How do you prove that your marriage was real? Which is the first step in all of these, all of these waivers. That's the first step. Before you get to, oh, but I'm divorced. Oh, but I was abused. Oh, but I will suffer extreme hardship. You need to show that your marriage was entered into in good faith. So you show that by including as many documentations as you can. So if you so basically, if you are trying to show that you have good faith marriage, if you're able to get your hands on your lease, if you file taxes together, and that's a good one. If you file taxes together, but you're no longer together, you're not able to get the documentation from your spouse, best way to do that is to just get it directly from the IRS. Right? Because you filed jointly, you have equal rights to get the documents, so you can actually apply to get that. If you had a lease together and you signed the lease and your name is on the lease, you can get a copy of that from the landlord, right? So basically, we need to find all the different documents you can get without asking your spouse, right? Without asking the person that's not willing to file jointly with you or not able to file jointly with you. Okay. So it is really, really important, and that you have as many documents as possible. If you have pictures together, if you have text messages, like sometimes you don't have all those other documents, you're not able to get the lease or anything like that, but you still have your text messages with the other person. Don't delete your text messages just because you're mad, because you still have to prove that your marriage is real. So again, you want to make sure that you are building your that you have that documentation and you are building up your documentation so that when you are ready to file, you're able to show that good faith marriage. Now, I'll tell you what happened at one of my interviews where there was, like I said, the woman with the restraining orders. There were several restraining orders back and forth. And the interview was literally 15 minutes for the removal of conditions. She was so nervous. She thought that it wouldn't be approved because of the restraining orders. But the officer said something that really made her realize like she had no reason to be so worried because of the restraining orders. The only purpose, right? The only thing the officer in a removal of condition case is there to figure out is, was the marriage real? Right? If the marriage was real, but you are now divorced and you have the divorce decree, the officer has to approve the case. So even if you have a restraining order, typically the restraining order will show that you, that your spouse is the one filing the restraining order, stopping you from coming to the marital home, staying away from your spouse, things like that. That is proof of your relationship. And the officer actually said, if your marriage was not real, you went through a whole lot of trouble trying to fake a marriage. Okay. So I want you, if you're in that situation, not to be so concerned of whether you will still be approved if you have a restraining order against you. Remember, that is different from saying not to be worried immigration-wise if you violate the restraining order. Those are two different things. Having a restraining order against you generally will not cause immigration issues. But if you violate the restraining order, it becomes a criminal case that can then affect your status. So just keep that in mind. So I'm just going to go back to the questions. Benjamin is asking for a clarification. So Benjamin, I was just saying, if you asked if the I-130 is all you need to file for a child, and I was saying that it depends on whether the child is in the US or outside of the US. If the child is outside of the US, the first step is the I-130, and then when it gets to the embassy stage, you'll need the DS-260 and the affidavit of support form and the supporting documents. However, without knowing if the child is in the US, I can't tell you what other documents you need. If you want to have basically set up a time to talk to me, feel free to do that so that I can better guide you. I can't really give you any legal advice, but I can tell you that typically if the child is outside of the US, you'll be filing the I-130. If they're in the US and the person is an immediate relative of a US citizen, you can also file the green card application with all the supporting forms and documents. So I hope that answered your question. Okay. Hi, Erin. Welcome from Monrovia. Thank you so much for watching and actually for always watching. Thank you so much. Now, if you are in a situation where you're getting a divorce, but your divorce is not final, right? That's what typically happens. Your divorce is not final. You're in the process of your 2 years being up and you want to file right away. Depending on when your divorce is going to be final, U.S. immigration is going to ask you for the final divorce decree. So if you file before your divorce is final, just expect a letter from U.S. immigration asking you for that final divorce decree. Okay, so just figure out the timing and make sure that you are already in the process of filing for divorce and showing that you're already in the process of filing for divorce before you go ahead and do that. Just know also that you can, so I said there's like 3 different waiver options besides the death of the spouse. But those options, you can check off all of them, right? So if you are currently divorced and you were abused and it will cause extreme hardship for you, then you would go ahead and you can go ahead and check off all those three options. Again, you would have to present evidence for all those three options. Okay, so not only would you have to show that your marriage was entered into in good faith with documentation, but you would also have to show that you're divorced, that you suffered extreme hardship, and that you will suffer extreme hardship, and that you were abused. So if you check off all those three options, you're expected to basically um, answer for all of them in your application. However, I can give you information based on my experience. So if you are in a situation where your divorce is not final, you put in the information, you checked off the divorce and the abuse, and you get to the interview, and now your divorce is final, you are allowed to just go forward with the divorce being final. Okay, so if your divorce is final, all you really have to prove is that you entered into the marriage in good faith. Okay, you're gonna get your interview unless you can provide enough documentation to the officer that's going to review your form that they don't require an interview, which I have done for my clients, where he suffered abuse during the marriage, and we were able to get it, basically get him approved without an interview. We just had to prove the good faith marriage and the abuse, and they were able to approve his case without an interview. Now, if you don't have that situation and you're scheduled for an interview, that is your opportunity to show the officer, one, that you know your spouse, two, that you and your spouse live together. And if you have additional documentation of the relationship, that's really your opportunity to present those additional documents. It's really important that you pay attention to what type of documents that you are presenting, because you want to make sure it's stuff that's going to actually help your case and not hurt your case. Okay. I've seen situations where people want to include, you know, police reports that say that they don't live with the spouse when they actually did. That's not really helpful. If you're living with your spouse and the police report is saying that you don't live with your spouse, you can always try to get that corrected, but it might not be helpful to you to include something like that in your application if the police report is not accurate. Okay, that's what you really want to make sure, that all the documents that you're sending in is accurate and best represents your relationship and best conveys to the officer that your relationship was entered into in good faith and that now you qualify for this waiver. Okay, so it's not like a waiver like the ones I've talked about before on this page. It's not like that kind of waiver. Okay, it doesn't go as deep as that, but you still have to prove that you suffered hardship, that you suffered extreme cruelty, or that you were battered by your spouse. Restraining orders, police reports, court records of, let's say, I'm talking specifically about the abuse. So if you suffered abuse and there were restraining orders or there were court records, things like that, you can go ahead and include that to show the abuse. Okay, that's what would really convey that to the officer, and those typically do say that it was your spouse that abused you, right? So it's kind of like doing two things at once. You're showing that you had a good faith marriage, but that you were abused, all with one document. So it's really important that your case is well documented before you file, just so that you are getting the best possible outcome. Okay. So now what form do you actually file? Because that's something that I get asked a lot. I've had people think that they have to file to renew their green card instead of remove the condition. So please, please, please don't make the same mistake. Okay, if you have a 2-year green card, you need to file to remove the condition, not to renew the green card. So those are two different things. Those are two different forms, and you need to make sure that you are filing the right forms. Because if you, let's say you're filing jointly, you're still married, and you want to file jointly with your spouse, and you go ahead and file the application to renew your card instead of to remove the condition, you won't really know until they deny that application. And then now you've wasted however long it takes for them to deny it to then file to remove the condition. So again, you are filing a 751, not a 90. Okay, I-751 versus an I-90. If you're renewing, if you have a 10-year green card and you need to renew it, you file an I-90. If you have a 2-year green card and you need to remove the conditions, you file an I-751. Okay, so if that's if I can just get one person not to make that mistake, I'm happy. Okay, so again, just make sure you're filing the right forms. And Benjamin, my contact information, my number is right on the screen and in the description for this video. And like I said, if you're filing for a child that's outside of the US, first step is typically the I-130. Again, that's typically, but there are situations where you might need additional things depending on your particular situation. So just make sure if you're filing on your own without a lawyer that you are looking at the instructions for the forms and including all the required document for your particular situation. Okay, so that is it for that. Now, can you work while the removal of condition is pending? Short answer is yes. Yes. You can work, you can travel, you can still do everything you did while you had the card that's still that hasn't expired. Okay, you're still a green card holder. So even though you're filing to remove the condition, you are still a green card holder. You just don't have the card to show it, right? But when you file, you're gonna get a receipt. The receipt is going to extend your status for 18 months. So if you need to renew your license, if you need to do anything like that, you can take that receipt to the DMV, RMV, depending on where you are, and they can actually use that as proof of your status. If you're applying for employment, you can, again, use that receipt that you receive for filing for the removal of conditions to work. So remember, the card is expiring, but your status is not until USCIS makes a final decision and you go to there's a whole other steps that need to happen. So remember, even if the card itself physically expires, you still have status. Once you file the 751 and you get the notice, it extends your status for 18 months and you can use that to work, to travel, and to basically anything you need proof of your status for, you can use that form as the proof of your status. Okay, so remember, you may it's not a must. You may get an interview. I've had situations where my clients didn't get an interview. And this is both for people that filed jointly and filed a waiver for abuse or divorce. So there is chances that you might not get an interview. So just keep that in mind. The more documentation you can show for your relationship, the more documentation you can show to prove the abuse. If you already have a final divorce decree, things like that will help speed up the process and hopefully lead you to not require an interview. But in most situations, you will have an interview. So just keep that in mind. I've had people that really believe that for this part of the process, there's no interview. Unfortunately, there is interview. So just prepare yourself for going into an interview. But if you're not scheduled for one, or if you're told that you don't need one, you can just be happy that you don't have to do that. But remember, just prepare yourself for having to have an interview. Okay. So, again, if you have any questions, please feel free to put it in the comments. If you are watching this on the replay, go ahead and ask me your questions so that I can respond. And if it's a really great question, or a question that I feel like a lot of people will get a lot out of, I will do an entire video responding to you. So again, feel free to ask your questions. If you find this helpful, feel free to share it. Like my page, subscribe if you're watching on YouTube. And if you're not subscribed to my YouTube channel, feel free to do that, because I do share certain, I share more videos there. So feel free to go ahead and do that. We do our lives here, but there are certain informations that I record and put up there. So go ahead and watch those. I think you'll find it helpful. But I really want to make sure that you are prepared for what's going on, right? Prepared for filing without your spouse to remove your condition. That's what we really want, right? We want you to be able to get that 10-year green card, be able to file for citizenship, all those things. So in order to do that, you need to know what options are available to you. And I hope this video was helpful in showing you that you have options, and that those options do not need to involve your spouse, especially if they are abusive. If you're already divorced, you have options. And if you were not abused, and you are not divorced, you have the but you and your spouse are no longer together, you have the option of filing based on extreme hardship. So this is basically telling the US government that yes, we entered the marriage in good faith or not, right? And we are now in a place where we're not going to file together. But if I had to lose my residency, I would suffer extreme hardship. So you can show this through your family situation. Let's say you have children that you are the one you are the one that's solely responsible for them. If you have medical conditions that you are getting treatment for, there's a lot that you can do to show that extreme hardship. You just have to make sure that you build up the case for extreme hardship. Okay. Sometimes it might be, some people do not want to get divorced, but their spouse also does not want to jointly file. So this is an option if you will suffer extreme hardship to get to still be able to remove the condition. Okay. So I think that is all I have for you today. If you have any questions, please continue to ask. And I hope you found this video helpful. If you have any questions about this or anything else, and you want to book a time with me, go ahead and we can schedule that over Zoom or in person. And you can do that by going to lilylegal.com or calling my office at 508-443-1788. And you can also request a consultation through WhatsApp at the same number. That is it for today. Thank you for your time. And remember, if you like this video, hit the like button. If you know someone who needs to hear this, please do share it with them. And if you are listening in a place that you can subscribe, like YouTube, and you don't want to miss anything, then go ahead and hit the subscribe button. Once again, I'm Attorney Lillian. I am the owner of Lily Legal, where we do immigration law and help our clients get status using the U.S. immigration law system. Okay, thank you so much for joining me today, and I will see you next week for more immigration chat. Thank you so much for your time. Bye for now.